very privileged to have none other than the CEO of ULS, Mr. Moses Okwalinga, to welcome us and tell us what to expect today. Over to you, Mr. CEO.
Okay, thank you very much. Good morning, the members. Morning, Secretary. Amy. The cluster. Okay. PPDA for having accepted to be part of this session. The procurements are a key component of legal practice, and I'm glad that we are having this session right now. Given what is going on in this country, there is a need for us to come to terms with the new developments. I think there was an amendment last year. Was it last year? The regulations. And personally, I will be eager to get to learn the various developments in the sector. To the membership, I'm glad that you find time to be part of this session. CLEs are not just for accumulation of points, but they're also for knowledge. So I'm glad that you've joined us this morning, and I'm hoping for a fruitful discussion. I bring greetings from the Council. President is supposed to be appearing before Parliament today on the tax amendment bills, so he wasn't able to join in, but the rest of the Council members will be joining online. Thank you very much, and we wish you the best during the deliberation.
Thank you, Mr. CEO. For purposes of introduction, my name is John Kalemera. I am a procurement specialist first and a lawyer second, a partner at the law firm Muhumza, Kateva and Company Advocates. I have the great privilege of being your moderator today, and we have to first know, why are we going to spend 3 or so hours listening in to the wonderful presenters today? And I would sum it up in one sentence: we need to follow the money. Public procurement accounts for approximately 60% of the national budget. Now, we all know that where there is money, there are going to be clients, and where there are clients, they definitely are going to be lawyers. So we need to figure out, one, how can we help our clients? How can we satisfy their needs when it comes to their participation in public procurement processes? Not only representing them, legal representation in disputes, but also giving them advice as to how they can participate better in their bids. Then, as lawyers, we also need to know how do we take advantage of that 60%? How do we participate by being the preferred legal service provider to some of these government entities? So we need to figure out, one, how to help our clients, and two, how to help ourselves. And that is what we are going to do here today. The question is the team competent to do that? I emphatically say that yes, they are very competent to guide us through today's proceedings, because each and every one of the panelists has not less than 20 years experience in litigation, a substantial part of that experience involving matters to do with public procurement. So I can comfortably say we are in safe hands. So the key takeaways today are, you as a participant, you have to, at the end of this session, know, one, these changes to the PPDA law, how do they affect me as a lawyer? How do they help me represent my clients better? And how do they help me deal with government as a preferred legal representative for certain government entities? Two, what are those essential things I need to have as a lawyer to be able to represent clients and government institutions. And what are the do's and don'ts in that regard? And finally, we're going to have hands-on experience from each of these panelists regarding these public procurement matters. So to start us off, we have Ms. Esther Kusima. Esther, her education background is quite diverse. She has a Bachelor of Laws from Makerere University. She has a diploma in legal practice from LDC. And she has a Master's of Law from the University of Pretoria. The bias is in international trade and investment law in Africa. She also has a certificate in public-private infrastructure projects from the University of Queensland and University of Pretoria. With regard to her experience, like I said, she has 20 years experience as an advocate. It's a very big plus for us here. So she's going to share that knowledge with us. What has she learned in those 20 years? She also started her career in private practice at the law firm Katera Kagumire. I think it's now H&G, where she served for 6 years. She was a lecturer of business law at Makerere University Business School for 6 years. And most relevant to the proceedings today, she was employed at PPDA. PPDA is a mouthful. It is the Public Procurement and Disposal of Public Assets Authority. So for purposes of brevity, we shall refer to it as the authority. She was employed at the authority for 5 years as a manager legal and advisory services, and thereafter as a regional manager. So clearly, she has quite some experience in procurement matters. And to add on that, she went on to become the head contracts and claims at the Uganda National Roads Authority, a position which she has held for 7 years and she still holds today. So with that vast experience of 12 years in matters involving public procurement, we are very privileged to have Esther with us, and she's going to be our first panelist. Esther, the floor is yours. You're going to guide us on the dispute resolution issues once a contract has been signed. Thank you.
Thank you, moderator, for the very generous introduction. Good morning, colleagues. It's a pleasure to be speaking to you today and sharing my experience on matters to do with public procurement.
Esther, this session is going to be collaborative for the key reason that we want our guests to be alert and to know what the issue is that we are trying to address and the answer. It's not going to be a monologue. I know it's the morning and people are still alert, but we want them to be very alert. They know what's the problem and how is this problem solved. So the first question I have for you is, when is a public procurement contract formed?
Thank you. I'll start by saying that a public procurement contract is not very different from the kind of contracts that we studied in contract law. It's a contract like any other. The only difference, I would say, is that there's certain additional matters that are introduced by the various laws under which procurement is conducted. The PPDA law being the principal law, and at times some of these procurements are funded by multilateral development partners who also have regulations governing their procurement processes. So those will also have an influence on the kind of contract formed, when the contract is formed, etc. However, for purposes of public procurement, a contract is formed when the contract is signed by the parties and issued by the procuring and disposing entity. So two key things to note: that the both parties should have signed the contract. In other words, a contract is not formed if it has been done orally. Under the Contracts Act, is provision for or recognition of oral contracts. But in public procurement, the contract must be signed by both parties and it must be issued by the procuring and disposing entity. So once those two things are done, then a procurement contract is formed. However, before we even get to that point, there are certain requirements that must be satisfied for an entity to get into the contracting process and signing. Things like confirmation of funding must have been done by the accounting officer. The accounting officer is in most times the head of the procuring and disposing entity, or any person that may be designated as accounting officer. So they should have confirmed availability of funding. They should have established that there is no complaint with the procurement process at that time. If there is a complaint, the process stalls until the complaint is disposed of, and then the parties can continue to contracting. The other requirement is that we talked about confirmation of funding. The accounting officer must also confirm that the bidder's price, the best evaluated bidder's price, does not exceed the estimate of the procurement established at the beginning of the procurement process. So how it works is that when a procurement process is to commence, the accounting officer is supposed to go to the market and conduct market sounding to have an indication of what the cost of the procurement shall be, and that then serves as a guide through this process, that should the bidder's price exceed this price established at the commencement, certain things need to be done. So that check must be conducted before a contract is signed. And then the other thing is that there's a 10-day period from the point the entity determines who the best evaluated bidder is and then displays the notice of that best evaluated bidder on a notice board. So 10 days must lapse from that period, and before the lapse of the 10 days, you can't sign a contract. So once those requirements have been met, then both parties must sign the contract, and then it has to be issued. Only after that has been done will a contract be formed in public procurement. Thank you.
Thank you, Esther. One key thing we can pick out from that is, in ordinary contracts, the ordinary contract can be formed even orally. You can have a verbal contract and maybe later on reduced into writing or not. But I think the Contracts Act also provides for reducing contracts above 500,000 and more into writing. But for public procurement, you cannot have an oral contract. That's absolutely not possible. It must be in writing, and like Esther has said, there are certain preconditions that must be met. But these preconditions are on the back end. A bidder would not know about them. A bidder would not know about the accounting officer having confirmed funding and etc. etc. But one thing a bidder can know is that 10-day standstill period that Esther has talked about. That standstill period is ideally to enable any aggrieved person challenge that award of the contract to a bidder through a process known as administrative review. So if you have seen your name on a notice board as the BEB, as we call them, the best evaluated bidder, don't get too excited and rush to the bank, withdraw money and start celebrating. you must know that there's a 10-day standstill period within which someone can complain and challenge the award of the contract to a bidder. And as lawyers, you also need to know this, because if your client is in this situation and the entity approaches them and says, no, you signed before the 10 days, I think there can be an issue. Esther, please tell us about the issues that arise if someone signs a contract within that 10-day standstill period.
Yes, I would like to mention that it's not just the 10 days standstill period that would impact the validity of a contract. All the issues I've talked about, much as there may be internal issues for the entity, the procuring entity, to ensure that they are complied with, they affect, or they have the effect of vitiating the contract. So it is important for both parties involved that all those preconditions are met before a contract is formed. Otherwise, if there is any party who is dissatisfied with the procurement process, it will be very easy for them to jump on any of those issues and claim that certain steps as required by law have not been complied with, and therefore the contract as it stands is not a valid contract. Now, regarding the 10-day period, the PPDA law is very clear that from the date one, there is a requirement after the entity has determined who the best evaluated bidder is. This information must be published on the notice board of the entity, as well as the website if they have a website. Now, this notice, or the publishing of this notice, must run for at least 10 days, and that's what we call the standstill period. During the 10 days, the law is very clear that no action shall be taken on the contract until the 10 days have run out. And so if there is an attempt by the parties to sign a contract during this period, the contract is invalid. And we have had several cases before the tribunal, and I think before the courts of law, that have found that you cannot have a valid contract if it has been signed before the lapse of the 10-day standstill period. So in addition to the standstill period, all the parties must ensure that all the prerequisites to signing of a contract have been complied with for the contract to be valid. Otherwise, it's possible for the contract to be vitiated.
Thank you, Esther. And after you have, well, one, we'll just clarify that notice of award does not amount to a contract, as Esther has eloquently stated. And this also, I think, came up in the Supreme Court case of Galleria in Africa. We can share the citation in the chat, which made it very clear that you must strictly follow the provisions in the PPDA Act in all the public procurement process, and you can only have a contract after you have signed that contract in accordance with the Act. In that case, the bidder had been awarded the contract, but a contract had not been signed, and the bidder went ahead to import certain materials in anticipation of signing the contract. However, for certain reasons, the entity did not proceed and sign the contract with that bidder, and the bidder challenged the entity. The court came out very clearly on the fact that because there was no written contract signed in accordance with the law, the bidder did not have a valid remedy, and so they threw out the bidder's appeal. Next question, Esther, is: are there certain requirements that must be fulfilled immediately after signing a public procurement contract? And if so, what happens if these requirements are not fulfilled?
Thank you. They depending on the agreement of the parties, which agreement, of course, is contained in the contract, they may or may not be certain conditions or requirements in the contract for it to become effective. So the parties may have signed, contract is formed, but if there are conditions for effectiveness of a contract, then those conditions must be fulfilled, otherwise the contract will not be effective. And the law lists some of these conditions. They may not, you may not find them in each and every contract. It all depends on the nature of contract and the agreement of the parties. However, some of these conditions include the requirement for the bidder or the provider to provide a performance security. This security is given to the entity to guarantee performance of the bidder. The other is the requirement for an advance payment guarantee, and this will only apply in those contracts where advance is to be paid to the contractor. So under the PPDA regime, no payment is to be made to a provider in advance of them providing either the services or supplies or whatever it is. So the standard position is that the provider delivers first and then payment follows. However, the law recognizes that in certain circumstances there may be need to facilitate the provider with some money. In case of a contract of works, this money helps with mobilization. If there are certain things that the provider needs to, or the bidder needs to get for the works to start. For instance, he may need to buy equipment, he may need to bring in experts and so forth who are required for the works to start. The advance that is granted in that case may help to facilitate those activities. Also, in the case of supplies where they are custom made, many of these manufacturers may require that certain money is paid in advance for them to start on the manufacturing process. So the advance is given to a bidder to allow for such. However, the law requires that where advance is provided, there must be a guarantee, an advance payment guarantee that is given by the provider to the entity. Usually it's a bank guarantee. It's actually a bank guarantee that the provider gives the entity. So if the contractor has provided that there's going to be provision for advance payment, then the provider must bring the advance payment guarantee before the contract takes effect. The other requirement could be, yes, still regarding the advance, where the provider has provided an advance payment guarantee, the entity is obliged to pay the advance to the contractor, or to the provider. So before advance is given to the contractor and an advance payment guarantee is provided, the contract will not take effect. The other could be provision of letters of credit. If the parties have agreed in the contract that payment is to be made by way of letters of credit, then acceptable letters of credit must be provided in that case before the contract takes effect. There could be other conditions other than those that are listed in the law. The law is that just provides examples of preconditions, but the parties are at liberty to agree on any others. Some may include, for instance, in a contract for instance, roadworks, there may be an obligation on the entity to provide a certain percentage of the right of way, the section of the road that's going to be worked on. So at the commencement of a contract, the parties may have agreed that the entity should provide, for instance, 30% of the right of way, cleared and encumbered for the contractor to start work. So that now becomes a precondition. Until the 30% right of way is provided, the contract will not be effective. Or any other condition that the parties may have agreed on that for the contract to become effective. So until those preconditions have been satisfied by the parties, you'll have a signed contract, fine, but it will not take effect until those conditions have been met. Thank you.
Thank you, Esther. There's a distinction between contracts that are signed between the government of Uganda and providers which are fully funded by the government of Uganda, and contracts which are signed between the government of Uganda and providers which are majorly or partially funded by multinational organizations such as the World Bank, the African Development Bank, and the Asian Development Bank. So my question to you is, these contracts, do they apply in the same way under this regime of public procurement contracts? Are their terms and conditions the same, especially with regard to the subject matter of today, which is dispute resolution? Over to you, Esther.
Thank you for that question. Yes, as the moderator has said, their public procurement contracts can be divided into two types. One are those that are fully funded by the government of Uganda, and then there are those that are funded by multilateral development organizations or other funding partners. Now, depending on in the case of contracts that are not funded by government of Uganda, there are usually agreements signed between the government of Uganda and the funders of the procurement project. So depending on what may have been agreed between the government and the funders, you may have the PPDA rules apply to the particular procurement, or they may have agreed that the procurement would follow the rules of the multilateral development banks. John has cited examples: the World Bank, African Development Bank, and several others. So depending on what has been agreed, in the event that the government and the funders have agreed that the procurement is to follow the rules of the funders, you then have a slight difference, especially with regard to the conditions of contract. In this procurement contract, you'll have a difference between that kind of contract and a contract that is fully funded by the government of Uganda. For contracts that are fully funded by the government of Uganda, the contracting process will strictly follow the PPDA law. In addition to the PPDA law, PPDA as an authority has issued standard templates that are used for contracting. Now, the templates have conditions of contract. They're called the standard bidding documents that are issued by PPDA have a section that has a draft contract. And so when a procuring and disposing entity gets to the stage of contracting, they will then customize the template of the draft contract that is provided in the PPDA standard bidding documents and tailor it to the specific requirements of the procurement. Now, I'll say that the PPDA standard contract template is not as detailed as the multilateral development bank templates. And so, because it's not as detailed, it is usually used for contracts that are not complex and not very high value. So in this category, you will have supplies, usually contracts for provision of supplies, contracts for provision of consulting services, non-consulting services, and minor works that are not too complex, not too technical, not very high value. So those will usually use the PPDA standard template of contract. Now, for the bigger, more complex contracts, and these are usually works, we usually don't have very high value and complex procurements for instance, supplies, non-consultant services. It may be high value, but it will not be complex. And so in that case, the PPDA standard template would suffice. But for works contracts, they are a bit complex and usually high value. So in that case, you want a more comprehensive document, that will cover all ends, all the interests, cover as much of the interests of the parties as possible. And so in that case, you would want to use, a more detailed document. And so in that case, the templates that are developed by the multilateral development banks are usually what will be used in this kind of contract. Now, the major differences between the two, as John has already highlighted, will are to do with the dispute settlement process, especially for purposes of this meeting today. There are major differences in the dispute settlement process, the forum where disputes are settled, and the procedures, generally speaking. I don't know if it's appropriate for me to get into the dispute process at this stage. Maybe I'll just highlight it, and then later on I'll talk about it in detail. But under the PPDA law, the dispute settlement process is straightforward. If the parties disagree, they attempt to amicably resolve this matter. And usually, a dispute will get settled at the stage of amicable settlement because of what I mentioned earlier, that these are simple procurements. Not many times they're not really high value and they're not complex. So it is easy for the parties to quickly pick out what the issues in dispute are and sit and talk and settle them. So the PPDA provides for dispute settlement by way of amicable settlement, and if that fails, then arbitration. Arbitration is usually conducted under the Arbitration and Conciliation Act of Uganda, under the laws of Uganda, and the seat of arbitration is Uganda, and using local arbitrators. Now, the case is different in contracts contracts funded by the multilateral development partners. So, as I mentioned, these contracts are usually very high value, they are complex, and they usually involve a foreign party. A foreign party that is not willing or is not comfortable subjecting themselves to the jurisdiction of our local courts here in Uganda. So those contracts will provide for several mechanisms to resolve disputes. The first being amicable settlement. So the moment a dispute arises, parties are given the opportunity to try and have it settled at that level without escalating it. And then if this fails, there is usually a party that is given the power to entertain disputes in a contract. Now, this is specifically for works contracts. And this party is the supervising engineer or the consultant. So this consultant is supposed to be a neutral party in as far as disputes are concerned. That when the parties have a disagreement, they fail to settle it amicably, the matter is referred to the consultant or the engineer, who then hears from the parties and then makes a determination of the dispute. Now, if the parties do not agree with the determination of the engineer, they have recourse to what we call the dispute board. The dispute board is specifically provided for under a particular type of contracts, what we call, I don't know if you've heard about the FIDIC contracts. FIDIC is an international, is the International Federation of Consulting Engineers, who over a period of time have developed standard contracting terms to be used in works contracts world over. And many of the multilateral development banks have generally adopted the contracting terms that are issued by FIDIC. And those terms also have provision for settlement of disputes. So the dispute board is created under the FIDIC contracting terms. The dispute board may comprise of a single member or 3 members who are agreed to by the parties. If it's a single member, the parties jointly agree on who this person shall be. If it's 3 members, each party appoints 1 member, and then the 2 members appointed by the 2 parties to the contract then appoint the umpire to make the 3-member dispute board. So this disagreement with the engineer's determination is then taken to the dispute board, which then will also hear the parties and then make a determination. Now, if the parties are not satisfied with the decision of a dispute board, they have the opportunity to take this matter for arbitration. And the arbitration procedures are also provided for in the contract. Usually, it is arbitration using the ICC rules. ICC is the International Chamber of Commerce. So arbitration is usually under the ICC rules, but parties are free to agree on any other rules that will govern the arbitration. That's at the point of contracting. All these issues are settled at the point of entering into the contract. But in my experience, usually we have been opting to use the ICC arbitration rules. So in the contract, the parties also determine the seat of the arbitration and any other matters to do with the arbitration. The law applicable, etc., is agreed by the parties in the contract. So that arbitration clause in the contract then will govern the procedure and process of arbitration if the parties ever get to that stage. So that is under FIDIC. And well, as we all know, arbitration is final. Once the decision is issued, that is it. So that closes the dispute process in this kind of contracts. Now, we also have contracts that are funded by the EU. The EU has their own unique rules and also conditions of contract that are separate from FIDIC. So if in the funding agreement, the government of Uganda has agreed with the European Union, that the EU rules shall apply, it therefore means that the contract, the procurement contract, will be modeled along those lines. The terms of contract shall be the EU terms of contract, which provide for the dispute process. Now, under EU, the first stage in the dispute process is for parties to attempt amicable settlement. Or maybe what I forgot to mention under FIDIC is that parties have the opportunity to amicably settle this matter all throughout the disputing process. Even after they've gone to the dispute board has issued a decision, one of the parties is not satisfied, they can still sit down and talk. Even when the matter has gone for arbitration, before an award has been made, the parties can still sit down and talk. If they are lucky that they come to an agreement, the matter then ceases at that stage. So amicable settlement is an opportunity that is open all throughout the disputing process. So to take you back to the EU process also, or the EU rules also require that the parties attempt amicable settlement. Then, should that fail, the parties may opt for conciliation, where a neutral party is appointed to try and facilitate the parties to reach agreement on the matters that are in dispute. This is usually a professional, a technical person who can quickly grasp the issues and be able to facilitate the parties to talk and resolve the dispute. But conciliation is optional. The parties may or may not opt for it. So following that, then is arbitration. If amicable settlement has failed, and the parties have opted to go for conciliation, conciliation has failed. Or if the parties have not opted to go for conciliation, if amicable settlement fails, the other party then, the dissatisfied party notifies the other of the intention to go for arbitration. The arbitration still is governed by the EU rules in this case, which the parties would have adopted in their contract. So that is a major distinction between the PPDA dispute process and then the dispute process and conditions of contract for the multilateral development partners.
Thank you, Esther. Just a little housekeeping. If you have any questions regarding Esther's presentation, please type them in the chat. We shall be able to respond to them, but also at the end of her presentation, we shall have a Q&A session. Esther, could you, in your capacity as a head contracts and claims, give us an overview of the common disputes that usually arise after signing a public procurement contract?
Thank you. The most common dispute, I would say, is to do with the interpretation of the terms of the contract. The contracts, much as there is there are standard templates that the parties use. The contract itself allows for the parties to customize the template. Certain sections are customizable because you will not have one contract being exactly the same as the next one. So the entity is allowed to change certain sections of the contract to suit the specific circumstances of a given procurement. Now, in that process, there is a chance that, certain mistakes will be made, certain contradictions will be introduced, and so forth. Because remember, there are certain sections of the contract that are not customizable, they're standard. And if you change, there's a problem, because the law says that if you're to change the term, the contract form, you must obtain dispensation from PPDA. So certain sections of a contract cannot be touched, others the parties are allowed to change. But in doing that change, parties must be very careful to ensure that those changes are consistent with other sections of a document. Now, certain parties may not be careful enough to ensure that, or it may be a change that, given the fact that we are human, you may not realize the implication of a certain change on another section of a document. So you'll have sections which are contradicting. And then when it comes to implementation of a contract, there's then a problem. For the entity, you're very clear in your mind what you meant when you were introducing the change. It is very clear to you and obvious. But for the other party reading the contract, they're saying, I'm reading this contract and the interpretation is very clear in my mind. So there's a problem with the interpretation of a contract. And this may affect any sections of a contract. We've had examples of, these challenges coming up regarding anything to do with the contract. We had one very recently. I work with Uganda National Roads Authority as introduced. And so we deal with the really complex contracts. We had one to do with sectional handover. Sectional handover happens where a contractor is required to complete a certain continuous section, say 15 kilometers, within a certain period of the contract time. If the contract is, say, 3 years, we say within the first 12 months, the contractor should have completed a continuous section of 12 kilometers and handed it over for the public to use. And I'm sure you've seen, for instance, the Northern Bypass, while work was going on, certain sections of the road were being used. Now, you will have a section that says that sectional handover is allowed. And then you'll have another section that when you provide for sectional handover, you must specify what the length of the section is, within what time should it be completed, the penalty for failure to complete the section within the time allowed, and so forth. So the contract, on one hand, provided for sectional handover. It said sectional handover will be allowed. Now, the part of the contract that should have provided for the details of the handover was blank. So the contractor said there is no requirement for sectional handover because the section has not been specified. The time within which the section should have been completed is not specified. So you cannot even impose the penalty on me. That's just an example, and there are several other things. So the biggest dispute is to do with interpretation of the terms of the contract. Others obviously will be to do with breach of contract, especially in a case where you find that both parties are at fault. So each party is saying you breached, the other is also saying I breached. I'll still use the example of UNRA. When the contract commences, there's an obligation on the entity to hand over the site. The road must be handed over. Now, there are times when, if for instance, you're doing, the contract is for rehabilitation works, it means the road is already in existence, and so you're not going to have challenges of acquisition of land. So it is very easy to hand over the full site at the start of the contract. But there are more complex cases where sometimes it's a new road, you're building a road where none existed before, or you're upgrading a road which was previously Maram, and you wish to upgrade it to tarmac. Now, when you upgrade it to tarmac, you cannot use the existing road because usually it's a narrow road. It's narrow, probably the drainage is not properly done, and now when you're upgrading, you have to address all those. Usually it will require that you acquire additional land. To expand the road, for it to meet the standard of a tarmac road, you need to acquire additional land. Where you're going to do major drainage works, there was a small culvert, you now need to put a mini bridge, you need to acquire land. Land acquisition, as you may appreciate, is a very complex process in Uganda because, the nature of our land tenure system. So usually, UNRA will not be able to hand over the full section of the road at commencement. So the parties agree that we'll hand over a certain section, for instance, 30 kilometers continuous section for the contractor to start work, and then the rest of the site will be handed over as the contract progresses. So there are usually challenges. Sometimes there are land disputes which are in court, people get injunctions and so forth. And so even UNRA's planned timetable for land acquisition cannot be met. So UNRA delays on their part. But you may also have cases where the contractor is delayed. As UNRA has failed to hand over sites, the contractor has also failed to mobilize. Meanwhile, you've already given them advance. You've given them advance, but they failed to mobilize, or they are progressing very slowly on the section that you've handed over. So you have concurrent breaches. UNRA is breaching on the one hand, the contractor is also breaching on the other hand. So which party then now comes to complain about breach of contract? If UNRA wants to push them to say, you have a section where you can work, why are you delaying? They will say, no, I had already mobilized in a particular section and I was ready to start there. Now, if you're telling me to leave that section and come to another, that's going to disrupt my program, and so I need to claim. So there's a dispute now. We have in the recent past had disputes relating to guarantees. Guarantees provided by the bidders, especially the advance payment guarantees. Now, you remember the entity has already advanced money to this bidder, and the way the contract is structured is that this advance payment is supposed to be recovered by the entity from the payments that are due to the contractor as they progress with the works. So on each certificate that is presented by the contractor to the entity for payment, a certain percentage is retained to offset the advance. Now, the advance payment guarantee, remember I talked about it in the beginning, that for an entity to pay a provider in advance of their providing the service, there must be an advance payment guarantee. Now, that guarantee must remain valid for as long as the advance is not yet fully recovered. The advance payment guarantee may be reduced by the proportions of money recovered, but it must remain valid until the advance is fully recovered. So there are times, due to delays, for instance, I've just talked about the delays in the implementation of a contract. Because of the delays, the advance payment guarantee may expire before advance is fully recovered. And this is very common, especially for works contracts. Now, in a case where the advance payment guarantee is about to expire, a prudent entity would write to the contractor in this case and ask that they extend the advance payment guarantee, because clearly the advance is not yet recovered. And the contractor has a duty to extend the guarantee, because remember, the contract says the guarantee must remain valid until the advance is fully recovered. So sometimes you write to the contractor and say, the guarantee is expiring in a week's time, please extend it. And they just keep quiet. They will ignore you. But remember, you have your advance out there. You've already paid it to the contractor. So as an entity, how do you secure yourself? Other times, they may have been, the guarantees have conditions under which they may be cashed. The entity may go to the bank and say, certain things have happened, therefore I want you to pay that money that has been guaranteed under such a guarantee. So of course, the banks are usually not very happy to pay this money out, especially because, depending on the relationship between the bank and their client, the client may not have fully paid the amount of the guarantee to the bank, but because of the relationship, the bank may have agreed to give the guarantee, hoping that there will not be need for the guarantee to be cashed. But now the need has arisen, and so the bank is a bit hesitant and slow. And they start all these delaying tactics. Please confirm. They write to you asking you to confirm the account where the money should be paid. You provide the confirmation. They'll write back, please confirm XYZ. Now, as you're exchanging between the bank, next thing you see is an injunction stopping the cashing of the guarantee. So as the bank was, engaging you, the bidder was busy involved in the court, trying to apply for orders to stop cashing of the guarantee. And so that has been a challenge for us. We've had several of those cases coming up. And then if an entity is not alert, of course, the guarantee may expire before it's extended. And once it expires, it means, the entity is exposed, your money is out there, and there's nothing to secure it. In the case of a performance guarantee, if it expires, you better pray hard that this contractor performs, because if they fail to perform, you have no backup as an entity. And of course, that would mean that there's some serious explaining to do, because you have caused government financial loss. So we've had challenges regarding guarantees. The other disputes may also relate to breach of contract. I touched on that a bit, especially cases where an entity is recommending that a provider be suspended by PPDA. Now, for those who have been involved in these proceedings, the providers would really give whatever it takes to try and fight this suspension. If it means going to court to get an injunction, or to try and challenge the suspension by way of judicial review or whatever the case is, the bidders will not take this suspension without a fight. It is usually a protracted process, but in the end, it is what it is. If the entity is able to satisfy PPDA that indeed this is a deserving case for suspension, the bidders will then be suspended. But many will even take on, try and challenge the PPDA process. So this is another area where we commonly have disputes arising in public procurement. I think that is it.
Thank you, Esther. Just to add on to one of the things she talked about regarding advance payment guarantees and performance securities, it is a highly litigated issue in the courts of law of recent. And the interesting thing about these instruments is the way they are worded. An entity should be able to take this advance payment guarantee or performance security to a bank and say, pay me now. And the bank is supposed to comply within a period of, I think, about 5 days under the Uniform Demand Rules Guarantee. So Esther has explained the purpose of this. The advance payment guarantee is used when an entity has forwarded you money before you do the work or before you give the supply. And usually this is not in excess of 30%. The law provides a limit. They cannot give you an advance payment for more than 30% of the contract value. So knowing Ugandans and the way some behave, they get an advance payment. The first thing the person is thinking about is taking a trip to Dubai and enjoying themselves, instead of doing the work that you have been given this advance payment for. So that creates a challenge, because that advance payment is supposed to be used for mobilization purposes, to start off the works, or if it's a customer's supply, to start working on that supply. But they misuse this money. So once you misuse this money, the entity is supposed to be able to cash in that advance payment guarantee that you gave it. Or if it's a performance security, if you are supposed to do the works according to a certain schedule and you have just slept on the job, you've not done anything, the entity is supposed to be able to cash that performance security and recover some money since you have breached the obligation. Now, what bidders are doing, when they get wind, because being a client of the bank will first call this client and say, you know what, the entity has brought these securities, they want to cash them. You need to act fast. So the clients would run to the bank, rather to the courts, and seek to stop the cashing of these securities. Honorable Justice Mubiru and Honorable Justice Jean Rwakakoko have issued 2 decisions where they emphasize that these securities are payable on demand. And the principle is pay first and argue later. So as it is right now, providers are not supposed to be rushing to court to encash, rather to prevent the encashing of these securities. They should allow the bank to proceed and encash the securities, and then they can challenge the bank and recover the monies if it was irregularly or improperly done. Thank you, Esther, for that. Esther, we also need to understand in detail, first and foremost, what are the preliminary steps a provider should undertake when there is a dispute, bearing into account the fact that maybe not all disputes, maybe not all disagreements that a provider has with an entity amount to a dispute. So for those that do amount to a dispute, one, how is it established that it's a dispute? And 2, what are the preliminary steps that a provider, or maybe even an entity, since we're playing both sides, should do once there is a dispute?
Thank you. I like that you have highlighted the fact that not every disagreement results in a dispute. Now, in a typical contract involving involving, beyond certain amounts of money, there are bound to be disagreements on issues here and there. As I mentioned earlier, many of these disagreements are usually resolved by the parties sitting down and talking. The number of disputes that, disagreements that escalate to the point of disputes, I would say the minority of the disagreements that, would occur in a typical contract. As I said, the parties have the opportunity to sit and talk. And we must also remember that very key in this contractual relationship is the actual relationship. This is government you're dealing with, the biggest clients that you'll ever have, and you need more business from government in future. So parties are always alive to this fact that, the relationship with the government is the most important in all of this. And for this reason, parties usually try and avoid having these disagreements escalate to the point of a dispute. And for it to get to that point, it means that, this relationship has irretrievably broken down. So much is at stake that the parties are opting to put the, contractual relationship aside and go full blast for the dispute process. Now, having said that, when a disagreement arises, both PPDA and the conditions of contract that are used for donor-funded projects will require that the party affected gives notice to the other party. And this notice is required to be in writing. So if an event occurs that's likely to result in a dispute, the other party, the party that's notified is affected, is required to write to the other party to inform them. And the primary reason for writing is for the other party to be able to take steps to address this issue before it escalates to the point of a dispute. That is the point. The point of a notice is really not to set the parties in combat mode, but it's for the other party to take note of the event that has occurred and be able to address it so that it does not escalate to a dispute. If, for instance, I'll give you an example sorry, I keep using examples from my entity because that is where they're the ones that easily come straight to my head. Now, in the case of UNRA, in a construction contract, UNRA is obliged to provide the site where the contractor should work. Now, as I've explained to you, many times it may not be possible to provide the site as agreed by the parties for whatever reasons. There is a land disagreement between the owners of the land, and therefore UNRA cannot access that section of the land. So you find the contractor has worked up to say kilometer 10. Now, there is a 300-meter section between kilometer 10 and 11 that UNRA has no access to. The contractor has to skip that and go to the next. While he's working on that, UNRA says, now this one is available, he has to come back. Remember, all this involves transferring your equipment and plant and then stuff back and forth. So that disruption is an event that a contractor is entitled to claim for, because one, it's most likely slowing him down, but it may even be costly. Imagine equipment that has to be, assembled. It means that when you finish a section, you've skipped a certain section, go and work at another section ahead, and then you have to come back. It means, you have to reassemble equipment, bring stuff. It's disorganizing, it's costly, and the contractor is entitled to claim for that. So if an event occurs, the person must notify their party and say, look here, this is what is happening on the site. Or if it is a supply and someone is supposed to deliver supplies, whatever they are, and then COVID has happened, the airport has been locked, shut down, and so the supplies cannot be flown into the country. It means that the supplier is not going to be able to meet the timelines in the contract, and ideally under the contract, the entity is supposed to be imposing liquidated damages on this supplier for failure to meet the timelines. But the event has occurred, which the law recognizes that in certain circumstances, the parties may be blameless, where certain events have occurred and certain breaches have happened. The parties are blameless. So you write to the other party and notify them that this event has occurred. If you do not take steps to address it, this is the impact it's having on me, and I intend to claim against you for this. So the other party is then put on alert and they start to prepare. Sometimes they may be in position to address the event so that it is resolved at that level. Or they may be put on alert that, there's going to be a delay in this party performing their part of a contract, but the delay is because of certain circumstances. That means, therefore, that at the end of the contract, where an entity, for instance, would have been charging liquidated damages, they will know that I can't charge because of certain events that I was notified of. Now, under FIDIC, the law, the conditions of contract go ahead to state, both FIDIC and the EU rules, that should the party required to give notice not do so within 28 days from the date the event occurred, from the date they got to know of the event, or the date they ought to have known of the event's occurrence, they then lose the right to claim. I will repeat that. Under FIDIC and under the EU conditions of contract, if the party that is affected does not provide the other party notice within 28 days from the date they got to know or ought to have known of the event's occurrence, they then lose the right to claim, and the other party is discharged from any obligation they would have had under that event. PPDA is silent on the notice period. It just says you give notice, and so it remains to be seen what should happen if, for instance, you notify the other party at the end of the contract. I don't know what would happen in that case, but FIDIC is very emphatic on the 28-day rule. And so that is a requirement or a prerequisite for a party claiming under a contract. You ought to have given the other party notice. I think that is it.
Thank you, Esther. You've heard it from the person who gets involved with these matters on a day-to-day basis. Notice is extremely key in these contracts. If you're to be able to sustain your dispute with the entity, you must give notice within that 28-day period. And if you don't, you lose out on the right to have your grievance resolved. Now, Esther, please quickly walk us through what happens after you've given this notice. What steps are taken from the point you've given notice? We assume notice has been given. So how is the dispute resolved? Can you please take us through all the way from the first to the last stage?
So once notice has been served, I will start with the contracts and the multilateral development partners. Once the notice has been served under FIDIC, the parties have the party that has served the notice has 42 days within which to file their detailed claim. Now, there are certain claims that are continuous. The example of land is the most clear one. That UNRWA, for instance, could have delayed to hand over site. And as soon as the delay occurs, you write to UNRWA notifying them, and then you even file your detailed claim. But even after the 28 days or 48 days, UNRA may still not have handed over the land. So the delay is continuing, and it may be anything else. So in that case, after notifying UNRA within 42 days from the day the event first occurred, I mean from the date the party got to know the event or ought to have known, 42 days from that date, the party must have filed the detailed claim before UNRA, before the entity, sorry. And then every month after that, you file an interim claim notifying the entity of the impact that the continued delay has had on the progress of the work. Otherwise, if it's a one-off event, within 42 days, you file your detailed claim, and then the dispute process starts from there. As I mentioned, the engineer is the first point of reference. So the claim is filed with the engineer. And the engineer has 84 days within which to determine the dispute. So within these 84 days, you would have, called the parties and heard from them. You would have requested additional documents and so forth. They would have given the opportunity to the other party to file their reply and attach, relevant documents and so forth. So all that process happens within the 84 days. And so the engineer handles the dispute and issues his determination. The powers of the engineer and the timelines and so forth are all provided for in the conditions of contract. I mentioned that once the engineer has made his determination, if any party, well, first of all, we need to note that that determination of the engineer is binding unless it's binding on the parties unless it's overturned. So if the parties are not satisfied with the engineer's decision, they have the option of going to what I call the dispute board. This is under the PD conditions of contract. The dispute board may be a one-member or a three-member board, as I mentioned. And so the party that is not satisfied with the engineer's determination then files a dispute before the dispute board. Oh, sorry, I mixed up the process. The 84 days, 42 days and 84 days that I mentioned, 42 days will apply to the engineer. Now, the 84 days to have this matter determined apply to the dispute board. If a party has, filed a matter before the dispute board then issues directions on how the process would follow. And within what time, the dispute board will normally call for a meeting of the parties, and then it is agreed within what time the other parties to file their reply. If there's to be a rejoinder, the parties will agree. If there's to be a hearing, the parties will agree on the date for the hearing. And then when the dispute board would finally issue its decision. So all this is done within a period of 84 days from the date the dissatisfied party first filed a dispute before the board. So within 84 days, the dispute board issues its decision. And if the parties are not satisfied with the dispute board's determination, they can then go for arbitration. Now, the party that is not satisfied with the dispute board's decision must issue a notice of dissatisfaction within 28 days from the date the dispute board's decision is issued. If they don't file that notice of dissatisfaction within 28 days, they then lose the right to go for arbitration. So it's important for us, as practitioners, to read and follow these requirements so that we're able to properly advise our clients. So the notice of dissatisfaction is written to the other party, telling them that they're not satisfied with the dispute board's decision and that they intend to go for arbitration. It also has a brief summary of the issues of disagreement. And then following that, the arbitration process then follows. There's a whole detailed section on arbitration if you look at the conditions of contract in both FIDIC and the EU. The EU actually has a separate booklet on the dispute process. So, and this booklet, I think it's accessible on the EU website. If you look at, I think it's called. Sorry, I'm going to find the reference and share it in the chat. So you can access this document, download these documents from the website, EU website, and they are very detailed on the dispute process. So if a dispute ever came before you, it's important that we, go through these dispute conditions, the rules governing the dispute process, so that we're able to follow them to the latter, and to avoid, any issues or potential challenges in the process. Now, for FIDIC, the contract itself, the terms of the contract have a section on arbitration, on how the arbitrators are appointed, from where the parties pick the arbitrators from, how they are paid, where the seat of the arbitration shall be, the law applicable to the arbitration, and so forth. It's all provided for in the contracts. If you can access a copy of the FIDIC conditions of contract, you will find that information there. And PPDA. The PPDA dispute process is fairly simple. As I mentioned, the PPDA standard templates of contracts are, basic, simple, very easy to read and understand. And those are also available on the PPDA website. If you look for the PPDA standard bidding documents on their website, within the standard bidding document is the template for the contract. So that contract has the section on disputes. So in a typical contract for supplies, non-consultancy services, as well as works, actually all types of procurement contracts, the dispute process is that, parties attempt amicable settlement, and when that fails, they go for arbitration. I mentioned that it is rare in a PPDA governed contract that parties will get to the stage of arbitration, because these are simple, straightforward contracts. It's easy to discern the issues between the parties and to resolve them. And so many of the issues are resolved at the stage of amicable settlement. Rarely do we have matters proceeding to arbitration. However, in the event that the parties get to arbitration, the details on how the arbitration will be conducted are provided for in the contract. The arbitration is usually done, as I mentioned, under the Arbitration and Conciliation Act of Uganda. The law of Uganda is usually applicable. The appointments of arbitrators is also provided for. It's a fairly straightforward process. Now, for the works contracts, there's a works contract under PPDA. There's a slight distinction that they provide for adjudication. And the PPDA standard contracts usually provide for adjudication, I think, using UIPE, if I'm not mistaken. My colleagues would correct me. UIPE is the professional body of engineers, Uganda Institution of Professional Engineers. So it is from that institution that the adjudicators are selected. The parties will usually pick from UIPE, agree on either a single member or 3 members, if that is the agreement. These adjudicators would serve the same purpose as the engineer would serve in a FIDIC contract, for instance. So the parties agree on an adjudicator. He's an engineer, of course, and therefore he appreciates, the technicalities of the contract of works. And so this adjudicator, once appointed, will then hold a preliminary meeting with the parties where they agree on the procedure to follow. How, the detailed submission will be made, the reply will be made, the rejoinder if possible, the hearing, the timelines, all those are agreed at the preliminary meeting with the parties. And so once that's agreed, then the adjudication proceeds, and then the adjudicator will give his decision. In the event that the parties are not satisfied with the adjudicator's decision, they have the option of going for arbitration. And that is then the final level. Once the arbitrator has determined the matter, that is it. There's no, further appeal at that stage, except of course as provided for in the law. I think that's the dispute process in summary between if I may mention briefly, under EU rules largely follow what FIDIC provides, except under EU there's an additional step after amicable settlement. Under EU rules, the parties have the option of going for conciliation. As we may know, the conciliation process is non-binding on the parties, and it's just intended for the parties to have an opportunity to talk with a neutral third party, facilitating the talking. This person is usually a person that's experienced in the subject matter. The parties, of course, are the ones who appointed them, and the appointment is on the basis of their experience on the subject matter, and may also have experience in dispute resolution. So their role is just to facilitate the parties to talk, to resolve the dispute. This process is non-binding on the parties. They may pull out of it at any stage. They may decide that they are not bound by whatever has been decided at the conciliation and so forth. But it's an opportunity. When two parties are talking, sometimes tempers may flare, and that kills any further chance of the parties talking to resolve the dispute. But with this neutral third party, their role is to moderate this process of talking, and to try and help the parties see the bigger picture so that this matter is resolved at this stage. So if the parties are fortunate enough, they may resolve the dispute at the stage of conciliation. But if they're not satisfied with the conciliation process, EU does not provide for a dispute board. So after this stage, the parties will go straight for arbitration. The conciliation process is not a mandatory stage. In other words, after amicable settlement, if the parties are not agreed, they'll go straight for arbitration if they think they don't need conciliation. So it's not a mandatory stage, but it's an option that's provided for in the conditions of contract that the parties may explore. Thank you very much.
Thank you very much, Esther. You have heard it from the person who deals with contracts on a day-to-day basis. We are very grateful for that presentation. Just to have a very brief recap, she has proven to us that contracts in Uganda, they actually provide for alternative dispute resolution mechanisms, including amicable settlement, conciliation, and arbitration. However, it is absolutely important that as a lawyer, you must read thoroughly that contract and confirm what the provisions provide for. Do not rush to file a notice of intention to sue or make an application for summary proceedings, because the contract stipulates the form of dispute resolution. Esther, there are some questions that have come in through the Q&A and the chat. One is, what remedy does a bidder have if it signs a contract and returns it to the PDE for signature, and 2 months later the PDE purports to cancel the bidding process? I think it is only fair that this question should be answered by Mr. Uthman Segawa, because he is the member from the regulator, PPDA. I think he will be the one to answer this question.
Maybe, if I may interrupt, I may say something small. Uthman will respond to the rest.
Okay.
But as I earlier explained, that a contract is formed when it is signed and issued by the procuring and disposing entity. So it is important that, one, both parties sign. If one party has signed and the other has not signed, the question as to whether you have a contract shall arise. That is one. Secondly, contracts normally have preconditions for effectiveness of the contract. You may have signed it well and good, but the question is, have those preconditions for effectiveness of the contract been met? One is provision of the advance payment guarantee, if at all is to be advanced in the contract, then the entity paying the advance, then the bidder receiving the advance from the entity and also receiving a performance guarantee. If payment is to be made by way of letters of credit, the letters of credit have to be opened. Then I also mentioned that before the entity signs, there are all those things that need to be done in the background: confirmation of availability of funding, confirmation that there's no administrative review. It could be the case that, as you've signed, the complaint has come in. Once the complaint comes, the entity has to stall the process. You can't do anything under the law. So you need to find out exactly why it is taking the entity 2 months to respond. It may be a case that, Ministry of Finance has written and said, because of competing priorities, we no longer have money for this procurement. So if there is no money, the entity cannot go ahead to commit the government in a contract. When it has been confirmed that money will not be available for the procurement. So we need to establish exactly what happened. It may be a case that, there have been delays for whatever reason, admin reviews, administrative reviews, or whatever else it is. There could be an injunction from court. Or it could be a case that the entity can no longer proceed with the procurement given the circumstances. But Uthman will respond to the rest.
Okay. Another question from the senior counsel, Charles Kalumia. Does the doctrine of eminent domain obtain in Uganda, whereby the state has the right to assert its domain on any portion of the soil of the state on account of public exigency and for public good, such as the construction of highway, airport, etc.? I think I can read through the questions and then you respond after. The next is...
Sorry, what's the doctrine again?
The question is, does the doctrine of eminent domain obtain in Uganda, whereby the state has the right to reassert its domain on any portion of the soil of the state on account of public exigency and for public good, such as the construction of highways, construction of airports, etc.? The next question is, lately, the Solicitor General, when clearing procurement contracts, has insisted that dispute resolution mechanism is a court of competent jurisdiction in Uganda, even when the contract is with an international company funded by a multilateral financial institution. This has raised issues between the contracting parties. How is UNRWA dealing with this issue? And finally, when are liquidated damages applicable in an EPC contract?
Okay. Thank you for your questions. On the doctrine of eminent domain, of course, the state has the right to, assert itself, and especially in, you mentioned contracts to do with construction of highways, where the public entity needs to acquire the right of way to perform the contract. This will also extend to provision of electricity services, building of dams, where you need to acquire land. Now, were very aware, I assume, of the constitutional provisions on the right to property and the circumstances under which this right may be limited. That if you're to compulsorily acquire private property, it must be, and this I say with emphasis, it must be following a process of, I think it says full compensation, adequate compensation prior to the acquisition. What does this mean practically for us? In the case of UNRA, it means that by the time your contractor gets onto someone's land, this land has been assessed, valued, an appropriate amount of money paid to the landowner before your contractor can get on. Now, this has been a challenge for government in a sense that when people get to know that there's a project that is going to, is going to be implemented over a certain portion of land, immediately the value of the land shoots up. So before the project gets into the very serious stages, there's preliminary work that comes. Surveyors come, try and do some work. There are meetings that are held with local officials and so forth. Preliminary indications of values of land are obtained at that point, for the entity to start planning the compensation process. But the moment the landowners get to know that there are certain people from UNRA who came and, they were surveying, visiting the land and so forth, people start getting ideas. So you'll find that, UNRA has done its valuation, has even submitted the report to the chief government valuer, and the chief government valuer has approved the value of the land. Then after that, UNRA goes back to the land to try and, communicate the assessment to the landowners. Half the people are going to challenge the assessment, saying my land has been undervalued, this has not been considered, etc. So we have a challenge with agreeing on the value, the assessment of the land, of the value of the land for purposes of compensation. That is one. The other challenge is to do with disputes over ownership. You have land that is being managed by administrators of an estate. The administrators are not agreeing with the beneficiaries of the estate. You have absentee landlords. You have parties that were already disputing over the ownership of the land. UNRA has gone, to try and identify who the owner is for purposes of compensation, and you find there's a case in court. So there are challenges of who to pay. And so all those issues will affect this principle of eminent domain, that much as the state has the right to acquire whatever property it wishes for purposes of public goods, there are certain conditions in the constitution that have to be met before this acquisition can happen. So in practical terms, when UNRA is doing work, you've accessed certain sections of the roads, other sections you can't access. There are all these challenges happening in the background. Someone has dragged UNRA to court for trespass, and has obtained an injunction stopping UNRA from proceeding with the work. We have sections where the whole road is done, and then you have a little 200-300 meter section that's the only one pending, and work has stalled. Now, each time work stalls, I'll give you a typical contract. For instance, this construction of Kampala flyover. Some of you know it, at Clock Tower. There was a point we had a dispute over land. There's a portion of land that's opposite the Mukwano factory. There was a dispute there. And we urgently needed that land, because I think that's where the work started from that section. Now, each day that we were sitting waiting for this dispute to be resolved, UNRA was paying 300 million shillings. It's that bad. It can even be worse than that. But the constitution says, before you start your work, there must be adequate compensation given. So there's that challenge, and in fact, at the time UNRA had proposed an amendment to the constitution, which was bad default. UNRWA's proposal was that if there has been an assessment of land and the party is disputing the assessment, allow UNRWA to pay the amount that is assessed, and the work proceeds. Then you go to court for the balance that you think is due to you. That was the proposal, but parties did not give it a chance at all. Even before it could be explained to the public, it was shut down. So it died at that point. We are facing challenges of land acquisition. The costs of projects have escalated because of these disputes. We are unable to, in practical terms, to enforce this right of government to expropriate land because of those challenges I've mentioned. But that's what we're dealing with. In some cases, we're able to negotiate with landowners and they allow the works to proceed as compensation. Issues of compensation are being handled. But in many cases, UNRWA stopped, and I'm sure other government entities are stopped from doing work until there's been a resolution of the dispute. In some cases, if it is to do with ownership, private owners contesting ownership, what we do is to go to court and apply to deposit the money in court, so that after the warring parties have settled their dispute, they'll go to court and pick their money. But for us, once we deposit it in court, we're able to proceed with the work. So in some cases, that's what we've done. But others, we've had to bear the cost of paying daily charges to the contractor because they're unable to proceed with the works on those sites. Then SG, yes, we have also been advised by Solicitor General that any provisions in the contracts to do with arbitration should be changed to dispute settlement through courts of law. It's a big challenge for us because most of our contractors are foreign, especially for the problematic contracts, the bigger, more complex. Foreign contractors who are not exactly comfortable with having disputes resolved in local courts before courts that are not specialized, with all due respect. But Attorney General is the chief advisor of government, and so we do not have much choice but to change these provisions on arbitration to litigation. We have not yet had a case where we have to apply that provision on dispute settlement because we've just started this change. But we're yet to see how this will play out before the courts of law. And someone asked how is UNRWA handling. We have complied with the guidance of Attorney General, and we're now changing those provisions of arbitration to litigation. Probably sometime in the future we'll come back to share how this change has been applied. Then, when are liquidated damages applicable in an EPC? Liquidated damages. Maybe I needed a little bit more information on this kind of contracts for me to properly appreciate the question. But liquidated damages are due from the date a contractor ought to have completed performance up to the time when they actually, or during that period, from the date they ought to have completed up to the time they actually complete performance of a contract. There are delayed damages or a penalty imposed on the contractor for delay in, or a provider for delay, contractor in this case, delay in completing the works. Now, the contract will normally provide the maximum amount of delay damages that can be imposed and the daily amount that can be imposed. So, if a contractor, for instance, the contract provides that you apply liquidated damages of 0.1% up to a maximum of 10%. That should mean then that you have up to 100 days to recover the full amount of liquidated damages. Now, the delay could only be for, say, 50 or 60 days. So it means that you're going to be charging 1% per day for the entire delay period of 60 days. Or, if the delay continues beyond the delay period, you have 100 days of delay to charge damages daily, and you've reached the 100th day and the delay still proceeds. You cannot charge liquidated damages beyond that. So that will be the maximum limit, and after that the contract provides for what should happen in the event that the delay continues. One of the options is to terminate the contract. But I don't know if this answers your question. I didn't have full information or proper context. but liquidated damages are charged for each day of delay. Each day that the contractor delays to complete the project, taking into account extension of time. If there's been a reason to grant the contractor additional time, that time is added on to the contract period before a party can start to charge liquidated damages. If, for instance, in the case of a road project, you've delayed to hand over site by 50 days, the initial completion date should be extended by an additional 50 days, after which, if there is any delay in completion, the liquidated damages then start to apply.
Esther, just to that final question, I think the question was in relation to the fact that here we're not dealing with just the construction. This is an EPC. So whether that liquidated damages issue applies for the other parts, the E and the P, if that's probably what the person who posed the question had in mind.
Yeah. You see, it is, much as it's an EPC, it is one contract awarded to one contractor with timelines. Now, there could be delays depending on the construction of the contract. The parties may have agreed on timelines for certain actions to happen. For instance, in a construction contract, you may have agreed that there's going to be sectional handover. After the first 12 months, you'll hand over 30 kilometers of the road section, complete and ready for use. The contract will also go ahead and provide that should you fail to hand over that section, much as the contract is still going on, there will be liquidated damages for that section. So the contract should have clarified on how liquidated damages are to be applied. If you don't have that much detail, it then means that you will have to wait for the timelines provided for overall completion of the contract. And at that point, when you expect that the contract should have been completed, taking into account any possible extension of time, is when you then apply the liquidated damages. Otherwise, if you have milestone dates and there are penalties for failure to meet those milestones, those penalties will be applied as and when the milestones fall due. So if they were supposed to have completed something on a certain date, they failed to, it doesn't matter, the contract is still progressing. As at that date, certain milestones are due, and therefore any delays shall be penalized.
Thank you, Esther, very much for that elaborate and apt to the task presentation, because, like I explained, she has hands-on experience in her capacity as head contracts and claims UNRWA. Any further questions for Esther can be placed in the chat or the Q&A, and we shall respond to them at the end of the session. We are going to the next panelist, and a very senior lawyer, Mr. Nelson Nerima. His education background: he has a Bachelor of Laws from Makerere University, a diploma in legal practice from LDC, and a Master of Laws from the University of London with a bias in corporate and commercial law. Experience: he has over 20 years experience as an advocate. He was a lecturer at LDC for 11 years, and I was very privileged to be one of his students, though I don't think he remembered me since I was a bona fide backbencher. He also served as a head of the Department of Continuing Education and Legal Aid at LDC. He was a director at the Capital Markets Authority for 8 years. He is currently chairperson of the Staff Appeals Tribunal at the Uganda Management Institute and has held this position for 3 years. He is currently a partner at Nambale Nerima and Company Advocates, and he has been a partner at this firm for 17 years. Most relevant to our topic here today, he is a member of the PPDA Appeals Tribunal, and he has been a member of this tribunal for a period of 3 years. So we are very, very privileged to have with us Mr. Nelson Nerima, a distinguished advocate and currently a member of the PPDA Appeals Tribunal. Is going to take us through the dispute litigation process with regards to public procurement. So we are very glad to have you here with us, sir, and the floor is yours.
Thank you, Mr. Kalemera, for the kind introduction. And it's my pleasure to be here today with my fellow panelists. And I would also like to thank the Uganda Law Society for organizing this training on public procurement and disposal. I'm going to speak about public procurement and disposal litigation. I will give an introduction of the dispute resolution and remedial processes embedded in the public procurement and disposal process, but from the public law point of view, not from the private law point of view. My colleague from UNRA has talked about the dispute resolution between the individual contracting parties, and we are grateful for the professional expertise she has shared with us as far as the contracting process is concerned. I think all of us will agree that the contracting process is a matter of private law, private contractual rights between the parties, and when there is a dispute, there are mechanisms for resolving those contractual matters. Mine will be about the public law aspects. Before we even get into the performance of the contract, we have to ensure that the provisions of the law are complied with, and that if they are not, there are public institutions and bodies in place to resolve those disputes. I have a written presentation, and I have shared the slides. I'm sure immediately after this session, the Uganda Law Society will share these slides with all the members who have participated in this training. I will not read all the slides verbatim, but as we go along, I will pick out the salient parts of the presentation to emphasize. Of course, before we talk about litigation, we must bear in mind the major applicable laws. We've listed these, and our major legislation, as we all know, is the Public Procurement and Disposal of Public Assets Act 2003, as amended. Our colleague, Mr. Segawa, will later on take us through the amendments to the Act, and I will look forward to hearing from him. Of course, apart from the Act, we have a number of regulations. I hope you will also advise us on the process of amending these regulations to bring them in line with the Act as amended. We've listed the major acts, but this is not to say that these are the only laws applicable. Those are the major provisions, legal provisions, but when you are handling litigation, you must be an all-rounder. You cannot restrict yourself only to the procurement laws. Other laws also come into play, including the Constitution. Since all the audience members are lawyers, I'm sure they know the provisions applicable to litigation generally and jurisdiction. Now, we shall go to the actionable acts and omissions, because when you are litigating because you are complaining about a certain act or omission. In Uganda, we do not litigate merely to prove a point, or we don't litigate moot cases like it is when you are undergoing training. You litigate because you are complaining about a certain act or omission by a procuring and disposing entity. And you are alleging that a certain act or omission is wrongful. So in public procurement and disposal litigation, we are looking at the administrative, quasi-judicial, and judicial remedies for these wrongful acts or omissions in the public procurement cycle. And in this litigation, you are alleging that these acts or omissions are contrary to the Act or the regulations, or that they are contrary to the bidding document or any other binding requirement, e.g., we have guidelines issued by the authority. So when you think about commencing any public procurement and disposal litigation, you must bear in mind that it's not enough to complain. You must show that the impugned act or omission is contrary either to the Act, the regulations, the bidding document, or any other binding requirement, e.g., guidelines issued by the authority. Sometimes people litigate, but when you look closely, you find that their complaints are in respects of acts or omissions which are not contrary to anything. Someone is just complaining out of sentiment or the sentiments of his or her clients. There are many things you may disagree with, but if they do not amount to a breach of the Act, the regulations, the bidding document, or any other binding guidelines, then you have no cause of action. Now, a question arises: are the provisions of the Act mandatory or they are merely directory? We have a landmark decision, Galeria in Africa versus Uganda Electricity Distribution Company. I happen to have argued that appeal. My client, or rather the plaintiff, lost in the High Court, Commercial Division. The trial judge held that failure to comply with the provisions of the Act meant there was no contract. The Court of Appeal reversed and agreed with the plaintiff that compliance with the PPDA Act is an internal matter for the entity, and it shouldn't be visited on an innocent bidder. The Supreme Court reversed the Court of Appeal and held that there is no way the Act can regulate public procurement and disposal unless the provisions are adhered to strictly to the letter. The provisions cannot be directory merely. They are for all purposes and intents mandatory, and non-compliance with them makes the proceedings fatal. This is the decision of the Supreme Court. However, I want, if you get time, to look at the very detailed judgment of Madrama in the case of Sendege Senyon and Company Advocates versus Kampala Capital City Authority. This is where the advocates rendered legal services to Kampala Capital City Authority for so many years. And when the advocates put in their fee notes, instructions having been withdrawn, the authority said it cannot pay because the services of the advocates were procured without following the PPDA laws. The case was not heard on the facts. The judge was addressed on the law. And Justice Madrama held that the defendant should not be allowed to avoid liability for services heard and appreciated based on its express instructions. In other words, the judge was saying, if you take a benefit from someone, you must pay for it. Maybe later on we shall discuss, is this decision in conflict with the decision of the Supreme Court or it is not? Or if you offer services or supply goods in violation of the Act, but the entity has received the goods or benefited from the services, can we separate the goods or services from the procurement such that the court will say the procurement is illegal, however, pay for what you have taken? If your client constructs a highway for UNRA and the road is commissioned, but PPDA procedures were not followed. Will the court say that UNRA is not liable? However, it can keep the road. I don't know if that would be justice. So I would encourage lawyers to think outside the box and focus more on what is just, depending on the facts of each case. Probably it would be different if services or goods have not yet been consumed. But I think where you've consumed someone's goods or services, it might be a different story. Once again, I encourage all of us to read Justice Madrama's decision in the case of Sendege Senyon and Company versus Kampala Capital City Authority. Now, much as the act is mandatory, the same act also has provisions which say that the act is not applicable where the provisions of the act conflict with the obligations of Uganda arising out of an agreement with another state or states, with an international organizations, etc. In that case, the provisions of the treaty or agreement will prevail. Therefore, if a procurement or disposal is done under an agreement which provides for an alternative remedy outside the act, then when it comes to procurement litigation, please don't proceed under the PPDA Act, proceed under the remedial provisions of that agreement. So you cannot apply for administrative review. The courts and the tribunal have handled many cases where this issue is raised. An entity says, this is a loan from World Bank, and under World Bank procurement guidelines, there is an alternative procedure for dispute resolution. But many times when you read the alternative procedure, you find that it is in tandem with our act. For instance, the provision can say that if you have a complaint, address it to the permanent secretary. So if a loan agreement with the World Bank applies their procurement provisions, but their guidelines say you complain to the permanent secretary, does that conflict with the PPDA Act? I think no. So for the PPDA Act to be ousted in litigation, there must be clear provisions in that agreement ousting the public procurement processes as we know them in Uganda. Now, there are a number of common breaches which may found a cause of action, leading you to apply for administrative review or any other judicial remedy. There are so many, and I need not talk about all of them, but we've listed some examples. In your free time, you look at them and maybe even consider adding more to the list. These are the common breaches which may found a cause of action. Common breaches by procuring and disposing entities or their accounting officers. Now, as I said at the beginning, in public procurement and disposal litigation, we are talking about administrative remedies, quasi-judicial remedies, and judicial remedies. And the first remedy an aggrieved person has is what we call administrative review. Administrative review by the accounting officer of the entity concerned. For those of you who have not participated in these procedures, I will invite you in your free time or even right now to look at the definition of accounting officer in the Act. Some people who are not well versed with these terminologies sometimes think that accounting officer is equivalent to accountant, but it has nothing to do with accountant. So I encourage you to read the Act, who is an accounting officer. Find it in the Public Procurement and Disposal of Public Assets definition section, and also read the Public Finance Management Act. For instance, in most ministries, the accounting officer is the permanent secretary. But in some ministries, the accounting officer is not the permanent secretary. In some ministries, the accounting officer is the under secretary or another person, as the case may be. In the Ministry of Justice, I think the accounting officer used to be the under secretary, but it's now a permanent secretary. In the Ministry of Finance, there is a permanent secretary to the treasury, but he's not the accounting officer. The accounting officer is the under secretary. So it's important that we understand who the accounting officer is, because when we are applying for administrative review, the application for administrative review is addressed to the accounting officer. So in administrative review, the application is by a bidder who is aggrieved by a decision of a procuring and disposing entity. And that bidder will make a complaint to the accounting officer of the entity. So the ingredients for administrative review: 1, you are a bidder, you are aggrieved by a decision of the procuring and disposing entity, and therefore you make a complaint. So as you can see, one of the first things to note is that you must be a bidder. You must be a bidder who is aggrieved, and you must be aggrieved by a decision of the procuring and disposing entity, leading you to file or to make a complaint. Now, in the first bullet, you are aggrieved by a decision. But in the second bullet, as a bidder, you can also seek administrative review for any omission or breach by the entity. So there is a distinction. There is decision, then there is omission or breach. For definition of a bidder, please see section 3 of the Act. And the right to apply for administrative review is governed by section 89 of the Act. And there are regulations governing administrative review. These are the Public Procurement and Disposal of Public Assets Act, Administrative Review Regulations 2014. The regulations guide you on the time limit for making a complaint. They tell you that the complaint must be in writing. In practice, this is by letter or email. And you must pay administrative review fees. Now, the issue of payment of fees for administrative review has been very controversial. Many times, accounting officers dismiss applications or complaints on the ground that the complainant has not paid administrative review fees. However, I want us to take note of Circular number 3 of 2015, which was issued by the PPDA authority. And this circular guided that on receipt of an application for administrative review, the accounting officer should advise the complainant on the fees and where to pay the fees. The tribunal has also guided that late payment of administrative review fees is not necessarily fatal, and that even actual non-payment in court has been held not to be fatal as long as proper fees can be assessed and paid. Many accounting officers think that late payment or non-payment is absolutely fatal. But we've borrowed from the decisions of the court, including the Supreme Court, that a person's case cannot be dismissed because he has not paid court fees. So court fees are merely procedural, and so long as the proper fees can be assessed and paid, a person's case should be heard on merit, especially where it is the fault of the accounting officer not to guide on the quantum of fees and where to pay the fees. Now, what are your rights as a complainant? The entity must provide you with a report indicating the reasons for the rejection of your bid and the stage at which your bid was rejected. This is your right under the Act. Some bidders misinterpret this to mean that you must be given your competitors' bids and the evaluation report and the minutes. No. Your competitors' bid, the minutes of the contracts committee, the submissions, the evaluation report, all of those are confidential documents. You are not entitled to read them. Your right is just to be given a report giving reasons as to why your bid was rejected and the stage at which your bid was rejected. And of course, under our law, once the accounting officer receives your complaint, he or she must immediately suspend the procurement or disposal process. It's automatic. You don't have to run to court to apply for a temporary injunction. It's automatic that once you lodge a complaint, the accounting officer must suspend the process. The accounting officer must also request bidders to extend the period of the bid validity and bid security for the duration of the suspension. Because if bid validity is not extended, the procurement process might be rendered nugatory. Because once bids expire, then there is no procurement process ongoing. Now, how does the accounting officer conduct administrative review? In local governments, the regulations require him to appoint an administrative review committee to study the complaint and advise him. In the central government entities, it is not mandatory to appoint a committee to advise the accounting officer, but many accounting officers have adopted this practice. So in practice, whenever you make a complaint to the accounting officer, he or she will appoint an administrative review committee to study the complaint and advise him. But we should note that the opinion of the administrative review committee or its report is not binding on the accounting officer. It is advisory. And the accounting officer must apply his or her mind to the complaint and make his decision. Under the law, the accounting officer has 10 calendar days to make and communicate a decision. It must be in writing, and it must indicate reasons for the decision and corrective measures to be taken, if any. We shall now go to the second tier of litigation, which is the tribunal. The Public Procurement and Disposal of Public Assets Act, Part 7A, sets up the tribunal. It's appointed by the Minister of Finance, made up of a chairperson and 6 members, but currently we have a chairperson and 5 members, because one of the members was recently appointed to the High Court. There is a registry headed by registrar, and the tribunal, for those of you who don't know, sits at Communications House. Now, how do you appeal to the tribunal? Where the accounting officer does not make a decision, where he does not make or communicate a decision within 10 days, or where the bidder is not satisfied with the decision, you make an application to the tribunal. Your right to make an application to the tribunal arises in 2 ways. One, where the accounting officer fails to make a decision within 10 days. Or if he makes the decision but you are not satisfied with the decision, you apply to the tribunal. The law requires you to give notice to the accounting officer before making an application to the tribunal. So within 5 working days of being served with the decision, or within 5 working days of the expiry of the days given to the accounting officer to make a decision, you must give him notice that you intend to apply to the tribunal. However, the tribunal has ruled that failure to give notice is not fatal. It's equivalent to the statutory notice required to be given to the Attorney General or a scheduled corporation. The courts have ruled that failure to give notice is not fatal. Now, much as there is an appeals tribunal which hears appeals from decisions of the accounting officer, the law also allows you as a bidder to apply direct to the tribunal without first complaining to the accounting officer. And this is in situations where you believe that the accounting officer has a conflict of interest. However, if you want to appeal direct to the tribunal without complaining to the accounting officer first, you must plead and prove facts to prove that there is actually a conflict of interest. It's not enough to allege that the accounting officer has a conflict of interest. You must substantiate the allegation. Otherwise, if you apply to the tribunal without first making a complaint to the accounting officer and giving him or her a chance to make a decision, the tribunal will strike out your application that you omitted to first complain to the accounting officer. So whoever wants to apply to the tribunal direct without going to the accounting officer first has a burden to plead and prove reasons as to why he or she thinks the accounting officer has a conflict of interest. We shall briefly look at locus standi, or right to file an application in the tribunal. As we've seen, the people who have locus standi are a bidder aggrieved by an administrative review decision of an accounting officer, or a bidder where the accounting officer fails to make a decision within 10 days. Then there is also a bidder coming direct to the tribunal where he thinks the accounting officer has a conflict of interest. And lastly, any other person, even if he's not a bidder, whose rights are adversely affected by an administrative review decision. This is a third party who is not a bidder, but he alleges that his or her rights are adversely affected. But what does it mean to say that your rights are adversely affected? You must show a nexus with this procurement. It shouldn't be any busybody. For instance, can a taxpayer apply to the tribunal on the ground that the tender for the road has been awarded wrongly, and that as a taxpayer his rights are affected? I don't think so. So you must show a nexus with that procurement before you can allege that your rights are adversely affected. I will give an example without being exhaustive. If one bidder applies for administrative review, bidder X, and the accounting officer allows the application, the best evaluated bidder may apply to the tribunal, although he's not the bidder who applied for administrative review. The High Court has also ruled in a case where the complainant was not a bidder, but an old boys association of a school. The procurement was being done by a school, and the complainant was an old students association. And the court agreed that that old students association is a person whose rights are adversely affected. So it is a fine line, but it is important to show that you have a connection with the entity or the procurement and that you are not a mere busybody. Time limits. If you are alleging that the accounting officer failed to make a decision within 10 days, then you must make your application to the tribunal within 10 days. There is an error here. There is a word working days, which we shall correct the final version. So when you are alleging that the accounting officer has failed to make a decision within 10 days, as required by law, you have 10 days from the expiry of the 10 days given to the accounting officer. So if the accounting officer has until 18th April to make a decision and it fails, then you have 10 days from 18th April to make an application to the tribunal. However, if the accounting officer has actually made a decision within the specified time, but you are not satisfied with the decision, then you have 10 days, rather 10 working days. So the law was drafted in such a way that if the accounting officer fails to make a decision within 10 days, you have 10 days to appeal to the tribunal. However, if he makes a decision but you are not satisfied, then you have 10 working days to appeal to the tribunal. But you will notice that much as the act was amended, the regulations were not amended. So there is a conflict between 10 days or 10 working days. But I think once the act is amended, we have to take what is provided for in the act and not the regulations. Loss of locus standi. If your bid has expired, you are not a bidder and you cannot file an application with the tribunal. If you are not a bidder, you can only apply to the tribunal if you can show that you are a person whose rights are adversely affected. And if your rights are not adversely affected, you have no locus standi. There is no public interest litigation before the tribunal. The litigation must be by a person whose rights are adversely affected or by a person who is a bidder. Now, what is the jurisdiction of the tribunal? The jurisdiction of the tribunal under section 91I is to review the decision of the procuring and disposing entity. All of you understand the legal meaning of the word review. So the tribunal reviews the decision. It reviews the impugned decision. So long as the application is made within the time stipulated by the act. The tribunal has no jurisdiction to extend time stipulated in the act. What is the nature of the review conducted by the tribunal? I invite all of you to read the decision of Justice Mubiru in Arua Municipal Council versus Arua United Transporters. The nature of review conducted by the tribunal is what we call merits review, i.e., all aspects of the decision are reviewed. So the tribunal or merits review body considers both the lawfulness of the decision and the facts going to the exercise of discretion. However, we must distinguish review from judicial review. Because in judicial review, the court looks at the decision-making process. But in review, the person reviewing looks at both the decision and the decision-making process. So review is wider than judicial review. So the tribunal does not carry out judicial review like a court. It carries out merits review of the entire process. However, we should note that even when carrying out review, the tribunal respects the roles and functions of the procurement and disposal unit, the accounting officer, the contracts committee, and the evaluation committee, because under the Act and regulations, they are given certain discretion in the procurement cycle. They have a better appreciation of the facts and circumstances surrounding the procurement. So it is not proper, for instance, for a tribunal to start evaluating bids. The role of the tribunal is to determine whether the law and procedures were followed. And it cannot set aside a decision merely because it has a different view. So it is important to respect the space and expertise of the different players in the procurement cycle. Sometimes applicants say, my client's bid was the lowest, my client is more experienced, but I don't think a tribunal can start awarding points. That is not the work of the tribunal or even of a court. Limits of review powers of tribunal. As I have mentioned, the tribunal cannot take over the roles of the different role players in the procurement cycle. The tribunal only reviews the impugned decision and decides whether the applicable rules, regulations, and guidelines were complied with. There are certain matters which the Act prohibits the tribunal from reviewing, i.e., cancellation of the procurement process cannot be reviewed. However, the tribunal can review whether there is a cancellation. The tribunal cannot review the reasons for a cancellation, or it cannot even review a cancellation, but it can review whether there is a cancellation. It is not enough to say the procurement has been cancelled. The tribunal has to inquire into the facts and the law to decide whether indeed there is a lawful cancellation. Once there is a lawful cancellation, then the tribunal has no jurisdiction. But once the cancellation is not lawful, then the tribunal has jurisdiction. The law also provides that the tribunal cannot review the decision of an entity to discontinue the procurement or disposal process after receiving submissions from bidders, following an expression of interest or a pre-qualification. So if an entity has received submissions following an expression of interest or pre-qualification, then the tribunal cannot review the decision to discontinue such a process. And then a decision by an entity to limit the participation of bidders under a preference scheme or a reservation scheme. I hope Mr. Segawa will educate us more about preference schemes or reservation schemes. What I can say at this moment is that under the current law, if an entity decides to limit participation under a preference scheme or a reservation scheme, the tribunal has no jurisdiction to review that decision. We shall now briefly look at the tribunal procedure. The procedure is in the Tribunal Procedure Regulations of 2016. There is a form for making an application. It is Form 1 set out in the schedule. You submit in 8 bound copies. Filing fee is 300,000 shillings. You state the reasons for your application. And after you file, summons are issued. Response should be within 2 working days. However, the tribunal does not strictly observe the rules of evidence. That said, the tribunal, in any matter where the rules of procedure of the tribunal are not applicable, the tribunal applies the rules of the High Court. But we can direct the modification of the rules of the High Court to when applied to the tribunal. Conflict of interest by a member. If a member of the tribunal has a conflict, he or she must disclose and shall not take part in the hearing of that matter. Section 91L, automatic suspension of a procurement or disposal process, where a bidder appeals to the tribunal. Delivery of procurement action file. When a case is filed at the tribunal requires the entity to forward the file, all documents and bids to the tribunal for its scrutiny. However, the applicant has no right to view the file or the bids. And when the tribunal is reviewing a procurement, it is not limited to the issues raised by the applicant or the respondents. As a merits review tribunal, it reviews the entire decision and procurement to satisfy itself that all laws and procedures have been complied with. Hearings, parties file written submissions. Parties are given a few minutes to highlight their written submissions. Tribunal asks questions for clarifications, and the tribunal is proactive. The style is a hybrid of adversarial and inquisitorial systems. The tribunal aims to get to the truth of the matter through questioning, inquiry, and examination of all evidence. Since COVID-19, most hearings are conducted by Zoom. Decisions of the tribunal issues a decision within a period of not more than 15 working days after receiving an application for review. Disposition of applications. The most common dispositions are striking out application. This is usually if it's out of time. Dismissal, ordering re-evaluation, setting aside the entire decision and substituting it with another decision. And on costs, the usual order is that each party should bear its own costs. It is very rare for the tribunal to award costs. Appeals to the High Court. A party who is not satisfied with the decision of the tribunal may appeal to the High Court within 30 days. Section 91M says that you lodge a notice of appeal, which I think was an error, because you do not appeal by notice of appeal. You appeal by a memorandum of appeal. I hope this one will be corrected in the next amendment. Notice of appeal applies where you are appealing from High Court to Court of Appeal. You file a notice of appeal, then after getting the record, you file a memorandum of appeal. Otherwise, appeals to the High Court are governed by the civil procedure rules, and the procedure is memorandum of appeal. So I hope this one will be corrected. And I understand there is a judge who has made a decision that filing a memorandum of appeal instead of a notice of appeal is fatal. Yes, but I think it comes from the mistake which was made in section 91M. Maybe the section should simply have said you appeal to the High Court. The procedure should be left to the CPA and the civil procedure rules. And the appeal to the High Court is only on questions of law, not fact. However, even when you appeal to the High Court, the procurement process which had been suspended shall continue. This is the difference, is that during administrative review before the accounting officer and during the pendency of an appeal to the tribunal, the process remains suspended. However, if you appeal to the High Court, the suspension does not continue. The process resumes. And if you win the case, maybe you might be awarded damages, but the High Court will not reverse the decision of the tribunal or the accounting officer as far as the procurement is concerned. There is someone recently who attempted to get a temporary injunction or stay of execution from the commercial court to stop the procurement process. But the court invoked the act as amended and said, under the current law, the process shall resume and continue even during the pendency of an appeal. The decision of the High Court is final, and there is no right of appeal to any other court. Now, so far we've seen 3 remedies: administrative review before the accounting officer, we've seen appeal to the tribunal, we've seen appeal to the High Court whose decision is final. Question is, can you apply for judicial review in respect of the public procurement or disposal process? In the past, it was common for aggrieved persons to challenge procurement and disposal through judicial review. However, it is now settled law that judicial review may not be granted where there is an alternative remedy. So in view of the remedy of administrative review, court is unlikely to grant judicial review in public procurement and disposal matters. This is not to say that the court has no jurisdiction. It has, but it is unlikely because you have an alternative remedy under the PPDA Act. What about criminal prosecution? We all know that in Uganda, many people love criminal prosecution as a remedy because it can enable you to get to what you failed to get using the civil and administrative remedies. Section 95 of the Act, PPDA Act, creates criminal offenses. In practice, where someone, i.e. an accounting officer or any other public official, has failed to comply with the procurement laws and procedures, the DPP prefers charges of abuse of office. And many people have been charged with abuse of office for failing to comply with the procurement procedures. And the anti-corruption court has been convicting anyone where it is proved that he or she did not comply with procedures. But there is an interesting decision which has been delivered by the Court of Appeal recently, at the end of March. Kiwanuka Francis versus Uganda. This is what the Court of Appeal held. There is no presumption that if procurement laws are not followed, there must be prejudice caused to the employer. For one act to be prejudicial, it must cause actual harm or injury to the interests of the employer or any other person. Question is, if someone disregards procurement procedures, does that automatically mean that your employer's interests have been prejudiced? Or the prosecution must prove that as a result of your failure to follow the procedures, some loss or prejudice has been caused. The Court of Appeal is saying the prosecution must prove actual harm or injury. It is not enough to show that procedures were not followed. So in that case, the Court of Appeal set aside the conviction and quashed the sentence. But this is a matter for further discussion. With those slides, I have come to the end of my presentation, and I thank you for your attention.
Thank you very much, Mr. Nerima, for that very, very elaborate presentation. And I mean, how often do you get the person in the thick of things, the person who is part of the tribunal, giving you this very informative presentation about the do's and don'ts in the litigation process of public procurement? So what he says goes. He is the law. It's very important to take it very seriously. So, Mr. Nerima, there are very many questions for you to answer. But before we go into the questions from the panelists, I have some questions for you. One, does a lawyer need a valid practicing certificate to represent clients in public procurement litigation? Maybe I can just state the questions and answer after that. Two.
No, let me answer one by one.
Okay.
So, does a lawyer need a practicing certificate to represent a party before the tribunal? Under the Tribunal Procedure Regulations of 2016, there is a provision for what they call a representative. And this representative may be an advocate, an employee, or any other person authorized in writing by the applicant or respondent to represent the applicant or respondent at a proceeding of the tribunal. So an advocate is an authorized representative within the meaning of the Tribunal Procedure Regulations. And we all know that to represent someone as an advocate, you must be enrolled and you must have authority to practice. So the answer is yes. You must have a practicing certificate. However, in practice, the tribunal is not strict in demanding that lawyers present their practicing certificates. However, under the law, for you to purport to appear as an advocate, you must be licensed to practice law in Uganda.
Thank you very much. The next question is, in your experience as a member of the tribunal for a period of 3 years, is it your opinion that there is a rise in public procurement litigation